Hello, everyone, and thank you for joining us for this presentation on understanding the SEC's proposed new mining disclosure rules. Given the timing for this presentation, we're going to go ahead and get started. You should be able to see the presentation on the webinar screen that you logged into. If not, please follow the instructions on the invitation to log in online and view the presentation. You may also ask questions during the course of our presentation using the chat box, which you'll see in the lower left-hand corner of the webinar application. If time permits, we will answer as many questions as we can that we don't believe have otherwise been covered at the end of our presentation. Thank you. And with that, we will begin by introducing the panel for today's presentation. I am Jason Brenkert, and I will be the moderator for today's presentation. I'm a partner in Dorsey's Denver office, and my practice focuses on capital markets and public company compliance, and I represent numerous foreign and domestic mining companies in these areas. I am joined in this presentation by my fellow partners in the Seattle office, Kimberley Anderson and Chris Doerksen. Kimberley's practices focus on assisting clients in financing their business through strategic public and private offerings, and in guiding public companies through corporate governance and disclosure requirements. She likewise has a focus on mining companies in these areas. Chris's practices also focuses on capital markets work, both private and public, and on public company corporate governance and disclosure obligations, and Chris represents numerous mining companies in this regard. And all three of us are also members of our firm's Canadian practice group. We are delighted to be joined today by Barney Guarnera. Barney is a director at Behre, Dolbear, a leading mining industry advisory firm specializing in performing technical and strategic studies for mining companies and industry participants. Barney is also president of the Mining and Metallurgical Society of America, a leading organization of mining industry professionals. Barney has over 40 years of international experience in mining and consulting. So to start our presentation, we have here just the agenda for today. This is a quick overview of what we're going to be covering. I would mention that given the level of detail on the proposed new rules and the time limitations of today's presentation, we will not be able to cover every aspect of the new rules in high levels of detail. Our focus is to provide an overview of the key aspects of the proposed rules and highlight areas of concerns for issuers. A more detailed summary of the proposed rules was presented in our recent client update on the subject, which you should have all received and which we will resend following this presentation to the participants today. So to start out, why are we here and why is this important? So, currently mining companies provide disclosure under the SEC's Industry Guide 7, which sets forth the staff's guidance on mining company disclosure requirements. And this guidance is 30 years old and very outdated. Specifically, companies have struggled with the fact that Industry Guide 7 doesn't really provide a level of detailed guidance on mining company disclosure and technical requirements. And much of that is required to be disclosed is actually based on supplemental staff comment letters to Guide 7 and can be inconsistent based on the reviewer and the company. Many countries today have established mining industries utilize standards set forth by the Committee for Mineral Reserves International Reporting Standards, which we would call CRISCO. Guide 7 has substantial differences from these standards, including but not limited to not permitting reporting companies to report mineral resources. And these differences have resulted in many U.S. reporting companies being forced to disclose this different information on their websites and in press releases, but then omitting it from their SEC-filed reports and registration statements. While other reporting companies, specifically some Canadian foreign issuers that are reporting with the SEC, have been permitted to disclose some of these items, and therefore there's a discrepancy in the treatment of reporting issuers that many view as unfair and inequitable treatment. So these outdated disclosure requirements have resulted in industry participants requesting these new rules. Well, now we have these proposed new rules, and I guess the question is, are these a welcome change, or do we view these as being too restrictive? And does this expose companies to too much liability? So to cover an overview of the proposed rules, I'll now turn it over to Chris, who will walk us through.
Thanks, Jason. Well, the new rules are a welcome thing in terms of showing that the SEC is willing to move in the right direction and bring the SEC standards much closer to the international standards that have been adopted in other jurisdictions, including Canada, Australia, Europe, South Africa, Chile, and other jurisdictions. As far as summary of the rules, first, who would the rules apply to? The rules as proposed would apply to all SEC filers. And that would include not only U.S. companies, but also foreign private issuers, with the sole exception of Canadian companies that file exclusively under the Canada-U.S. multi-jurisdictional disclosure system. So Canadian companies that file on Form 40F would be exempt, but all other foreign companies would have to comply if they are SEC filers. Within that group of companies, the rules would apply to persons that own, operate, or hold royalties or similar rights with respect to mineral properties that are material to the company. So it is clear that royalty companies would be captured, but if a company had mineral properties that were simply immaterial, they would not need to comply. What do the rules provide for? Unlike existing Guide 7, the new rules would permit and would in fact require the disclosure of mineral resources that are not yet mineral reserves. Resources could not, however, be declared unless they were supported by what the SEC calls an initial assessment, which would be similar to but different from a PEA in Canada. With respect to mineral reserves, the rules are more specific than existing Guide 7 and would make some changes in the way that reserves are calculated. For example, it's proposed that reserves would now be able to be declared in a pre-feasibility study and not just in a final. And it's proposed that the maximum price that a company could use for the commodity that it is producing to calculate reserves would be changed from a 3-year historical average to a 24-month trailing average price. The new rules introduce also the idea of a qualified person, which would be a mining expert that satisfies certain qualifications, and a qualified person would be required to prepare all estimates of resources and reserves and prepare a written report for each material property that the SEC calls a technical report summary. A qualified person would need to be the author of all major economic analyses regarding a mining property, including any initial assessment or a pre-feasibility or feasibility study. Disclosures that companies put in their annual reports and registration statements would be expanded and more specific than in Guide 7, including a number of new tables that we'll discuss. The technical report summaries prepared by QPs would need to be filed as exhibits to annual reports and registration statements. One of the aspects of the proposed rules that we think will be quite controversial with Canadian clients is that, as proposed, the SEC would eliminate the exemption that Canadian 20F filers can currently use to allow them to include in their SEC filings both Guide 7 disclosures and the separate disclosure requirements required in Canada under 43-101 in Canada. Under the proposed rules, a Canadian 20F filer would now have to comply exclusively with the new SEC standards in its SEC filings. That would put Canadian 20F filers in the same situation as U.S. companies and other foreign companies under the current regime. The SEC has solicited comments on the proposed rules. We expect that many of our clients will comment, and in fact, many of them already have. The major industry organizations are also in the process of collecting comments from their members so they can submit comments to the SEC collectively. If anyone on the call would like to participate in that process, the SEC has disclosed in the proposed rules the method for submitting comments. The deadline for submitting comments is August the 26th, and you may also be solicited by various industry organizations for your thoughts. I'll now turn things back over to Jason, who will moderate a discussion of specific questions and concerns under the proposed rules.
Thanks, Chris. Our first question is going to be for Kim. Kim, maybe you can explain for us what the proposed rules set forth as a definition for a mineral or a material of economic interest.
Thanks, Jason. As we're going through the proposed rules, you really begin to understand how brief Guide 7 actually was. There's very little that's actually in it. For example, they really never defined mineral. They have done so now, and it now includes mineralization, including dumps and tailings, geothermal fields, mineral brines, such as lithium and magnesium, and other resources extracted on or within the Earth's crust. It very explicitly excludes oil and gas, which are covered by different rules, water and other gases, such as helium, etc. What this will really do is expand the number of companies that are going to be considered mining companies. So, for example, with respect to geothermal resources, those were not previously covered by Guide 7, and so now companies in these areas will become subject to all of the mining disclosure rules. One of the reasons, if you ask yourself why geothermal and mineral brine are now included, is because the SEC said that the scientific and engineering principles used to characterize those kinds of resources and reserves are substantially similar to those used to characterize solid mineral resources and reserves, which is very different from things like gases, which is why gases were accepted, but mineral brine was included. So, we believe that the world of mining companies will begin to expand and will probably expand substantially.
Thanks, Kim. One of the differences between Guide 7 and the proposed rules is the inclusion of mineral resources in the proposed rules. Can you run us through what is a mineral resource under the proposed rules?
Sure. So keep in mind that the SEC always prohibited the inclusion of resources unless you had the foreign law exemption, so they never bothered to define it. Was it necessary? They prohibited it. So they are now using really the standard industry approach of measured, indicated, and inferred resources, which of course decline in level of confidence as you move from measured to inferred. If you want to declare a mineral resource, it is going to require an initial assessment, which is a preliminary technical and economic study of the economic potential of all or parts of the mineralization if you're going to support the disclosure of mineral reserves. So if you're going to determine the existence of a resource, for example, the QP has to be able to estimate location, quantity, grade, or quality continuity, and other geological characteristics, including from geological evidence and other knowledge, including sampling. They also have to conclude that there's reasonable prospects for economic extraction based on that initial assessment. Now keep in mind that this will include a cutoff grade estimation, which we're going to be chatting with Barney about in a few minutes. So the one difference is the concept of how inferred resources are treated. Now keep in mind, inferred resources really have the lowest level of confidence attached to them. And so what the SEC has indicated is that the treatment for their treatment of inferred resources differs from SERISCO, because SERISCO allows a qualified person to actually make use of the inferred resources in technical and economic studies, as long as they include cautionary language. That's not permitted under the SEC's rules. So there are a few differences. The other issue with respect to inferred resources is that the QP is going to be able to make the statement that at least X% of those inferred resources are expected to be converted into indicated or measured resources. And keep in mind, you can't move something from inferred resources into reserves. They would have to first be converted into a higher level of resource. So, and the phrase I found most interesting is that a QP, when they're making these statements with respect to inferred resources, they have to be able to defend this expectation to their peers, which I found to be an interesting way to phrase it. So that's kind of a very, very brief overview of resource.
Thanks, Kim. And I guess the follow-on question to that obviously is, under the proposed rules, is there a substantial difference between Guide 7 definitions of a mineral reserve and the new proposed rules?
There is. The biggest, Chris already touched on, which is that you can now actually have it based on either a preliminary or final feasibility study. It used to be that it was only a final or bankable feasibility study that you were permitted to base reserves off of. So that has now been modified so that it is much closer to the Summaries standards. As we also stated, commodity prices are now based on a 24-month average or reasonable contract price. Keep in mind that when it comes to contract price, the word there is reasonable. Reserves are measured separate and exclusive of resources, so that you can't, there's no double dipping there. Under some of the Summaries standards, you have a complete measure of your resources, and your reserves are actually a subpart of those. But under the SEC's proposed rules, resources and reserves are two different measures. And I think that's similar to 43-101. But one of the interesting points is that there is very specific language and requirements within the modification of when you're preparing a reserve and determining a reserve relating to the accuracy and contingency levels required in a report relating to capital and operating costs. As you go from pre-feasibility study to a feasibility study, those requirements in terms of accuracy and contingency levels get tighter and tighter as you move to greater levels of knowledge and confidence. So what I would like to do at this point, because I think really we'd like to chat with Barney and get his thoughts on this. So Barney, you and I had discussed earlier the SEC's requirement that when you're determining resources, you have to consider modifying factors and a cutoff grade when disclosing and determining resources. Do you have any, how does that differ from current practice, for example, either under 43-101 or others?
Well, actually, even under Industry Guide 7, inherent in the definition of a reserve was some of these modifying factors, which basically was that the reserve had to be technically viable, economically viable, and legally viable, which meant that it took care of a whole plethora of issues. Here it's a little bit more specific, where basically the mitigating factors have been now stated to include geotechnical and hydrologic factors, as well as metallurgical factors, as well as mineral recoveries from the processing, and social and environmental issues. So all of these are now pretty well considered as part of the factors that need to be considered in both defining a resource and defining a mineral reserve. Now the cutoff grade, or as it's also called in the proposed rules, a break-even grade, is a common practice in mining. You want to make sure that you're not leaving money behind. They allow for the determination of the initial resource, you to assume you have reasonable assumptions that are behind the cutoff grade. In other words, it's not a detailed economic analysis until you start doing a detailed financial analysis where you have to basically show in detail the capital, operating costs, etc., all of the things that would go into a cutoff grade. It's also important to remember that the cutoff grade is an average. In other words, if you're looking at a copper deposit with an average cutoff grade of 0.5% copper, theoretically, you're looking at 50% having above 0.5 and 50% below 0.5. And this is one of the things that potentially is not a flaw in the policy, but a flaw in the way the mining industry works, because essentially you can be mining a lot of material that's not economic, that falls within that average cutoff grade. And part of the things that the industry has to do is focus better on maximizing the value it gets out of the mineral deposits they're mining.
Thanks, Barney. Now, with respect to your QP, so with respect to the statements that are now required about inferred resources, in terms of being able to defend those and being able to establish that, a majority of those inferred resources can be upgraded, Does the proposed rules give you any concern? Do you think that's going to change any particular practice when trying to declare an inferred resources, or is this kind of just same old, same old?
I think that it's a step in the right direction. There was a very well-known major mining company that always called the SEC the Flat Earth Society, and this is really a very positive step that they're taking to try to conform with other regulations and rules relating to the reporting for mineral deposits. The basic thing about the inferred reserves is that they are, to a large degree, speculative. And that is why these disclaimers are required about that they may never be converted to a measured or indicated resource. Now, the requirement that the certain percent, the qualified person has to put out a statement that he expects at least X percent of the inferred mineral resource to convert to indicated or measured mineral resources with further exploration and analysis. That, to me, is something that I can't answer as to its legitimacy, but it certainly does put a constraint on the qualified person, who's probably going to be very concerned about liability if he misses the mark, even though theoretically it's been peer reviewed.
So moving on to the accuracy and contingency levels that are required in those reports. For the pre-feasibility study and the feasibility study, as we discussed, these are generally speaking within industry standards, but these are now going to be, baked into the rules. Do you expect that this will result in either any change in practice or any concerns?
Well, I think if they are, as you call it, baked into the rules, Kimberley, mandatory, I think it would be a problem. Recent experience has shown that the level of accuracy of feasibility studies has been far less than the plus or minus 15% that they are talking about. I think everyone who's on this call probably recognizes that over the last several years, we've heard of projects that were projected to cost $1 or $2 billion, suddenly going up to $6 billion, say. I think that if it's mandatory that this is the range, it could lead probably to some liability on the part of some of the companies, and particularly on the part of the qualified person who is taking responsibility for the document that's being produced.
Okay, so one last question before we move on to some disclosure points, and this is the $64,000 question. So is it going to be feasible to disclose the same resource and reserve numbers under, for example, 43-101 and the proposed rules as they're currently presented? In other words, if you took these rules under both of those regimes, could you come to the same set of reserve and resource numbers?
I would say that the resource numbers will very closely coincide, if not be exactly the same. The issue may be on the reporting of the reserves, and that is due to the change in the pricing requirement that the SEC is imposing here with the 2-year trailing average. Now, I think it's common knowledge that the staff, while it was never a published rule, opined that they preferred that the pricing be the lower of the current spot price or the 3-year trailing average. And that has been widely accepted by many of the Canadian listed companies. But under 43-101, you are also able to use other prices. You can use consensus prices from analysts. You can use long-term prices based upon past history. So that difference on the prices could result in a significant difference between the reserve that's reported on 43-101 versus on reporting to the SEC.
Thanks, Barney. Oh, and one point, I think when we were, someone posed a question that the 24-month trailing average, that would be based at the time of the estimation, correct?
No, my understanding is it's based upon the fiscal year that you do the reporting for the company's fiscal year. And that is, so it would be based upon 2 years of the 2 fiscal years of the company's reporting.
And clarify it.
Yeah. So to clarify, when you're doing the initial assessment, so the initial pre-feasibility study, the 24-month, and not the updating, which we may have different pricing. At the time of the pre-feasibility study, the 24-month trailing average, I believe, is going to be at the time of the estimation, or are you reading the rules that it's actually going to be based at the end of the fiscal year?
My reading was the fiscal year, and I could be incorrect on that. But it's important to make sure to differentiate between the initial assessment, which does not allow for a financial analysis, versus a pre-feasibility study, which is based upon a financial analysis to determine the economic viability.
I think we need to, taking a quick look at the time, let's go move quickly forward. So with respect to disclosure, keep in mind, if you're thinking to yourself that you really don't want to actually have to prepare resources in accordance with the new rules, you don't have to. But if you don't prepare them in accordance with the new rules, you can't disclose them. It's kind of that simple, or at least as the rules as proposed. So, but if you have made a determination of resources and reserves and so on in accordance with the rules, they must be disclosed. So when we're talking about what needs to be disclosed, very briefly, for companies with multiple mining properties, it's going to be a map showing the location of the properties, a table of your 20 largest properties by asset value with certain specified information on each property, and then a summary of all reserves and resources at your fiscal year end for properties with greater than or equal to 10% of your total reserves or your total measured and indicated resources. And then for each material mining property, there will be a table of your exploration activities, a comparative table of any changes in your resources and reserves, as well as some, more extensive narrative disclosure about that property. And then, of course, you will also have to file the technical report summary prepared by a qualified person.
Thanks, Kim. Chris, maybe you can discuss one of the primary additions to the proposed rules makes is that companies will now have to file technical report summaries. Can you discuss if and when a technical report summary must be filed and updated?
Absolutely. Under the proposed rules, a technical report summary would be required for each material property unless there are no reserves, no resources, and no material exploration results. So it'd be very rare that any material property would not need a report. No report, however, would be required for a non-material property. So the key first analysis for a company is what are your material properties. For each one of those, very likely to need a technical report summary. The initial filing of that document would normally be with the first annual report, in which you disclose for that property material exploration results, resources, or reserves. That document also would become part of any registration statement that is used. So you might see situations where perhaps you didn't have a report at the end of the year, but mid-year and prior to an offering, you determine you need to prepare a report simply to get an offering done. But generally it's filed with the annual report. And then once that first report is filed, an amendment would be required in connection with any new annual report or in connection with the use of a registration statement if there's been any material change in any of the information included in the report. The SEC did not generally adopt a new definition of materiality, so for the most part you would use normal standards in making that determination. But there are a few specific examples that the SEC's rules would deem material, and that would include any annual 10% change in resources or reserves other than solely through production, and any cumulative 30% change since the original date of the report in resources or reserves. So, it's hard to tell at this stage how different this would be from other jurisdictions such as Canada, but our suspicion is that this would tend to result in more amendments, particularly if reserves were to change because the 24-month trailing average price had changed, there may be requirements for an annual update in effect. But that's really going to depend on the facts applicable to that company and that project.
So let me ask you one question. We were chatting about this yesterday. If a company decides to first disclose their resources in a press release, which is very common, but their annual report, let's say they don't have a registration statement outstanding. So sometime in for a fiscal year-end company, they put out their a press release with respect to resources or reserves or what have you, and their annual report's not due for 4 months. Does the press release or the filing of that on a 6K or an 8K trigger the report of the filing, or do we actually have until the annual report before it has to be filed?
Yeah, assuming there's no registration statement and no concern about material misstatements or omissions in an offering, there is technically no requirement that any press release, 8K, or quarterly report be based on a qualified person. So I'm thinking of this akin to what many companies do, issue preliminary financial results at the end of a year well in advance of when they're filing their audited financial statements. They know they ultimately will need to go to the expert, the auditor, and get them to sign off on the numbers, but they do their own analysis to see, are they comfortable issuing some numbers ahead of time? And it would be a similar analysis. Ideally, of course, it wouldn't make sense to take that risk. You would want to, in most cases, I would expect, have the QP back what you're doing, even though it's not technically required yet.
Thanks, Chris. Well, you were mentioning the qualified person. What role does the qualified person play in these technical report summaries and the reporting?
Yeah, it really depends on whether property is material or not, but for a material property, once a property is material, a QP will really need to be intimately involved in all of the disclosure related to that property, prepare a technical report summary, and back the disclosures that the company is making. For non-material properties, less involvement would be required because there's no requirement to prepare a technical report summary. However, as Kim summarized, there are some disclosures that will be required in your annual report even for non-material properties. So for example, if a non-material property had a resource estimate on it, the resource estimate that's ultimately included in the annual report would also need to be backed by a QP, although a separate summary report would not be required.
And what kind of liability does this expose the QPs to?
That will be an interesting change for U.S. companies that haven't historically used QPs. A QP that is named in the annual report will obviously also have to be named in any registration statement, either by incorporation by reference or a direct reference. When that occurs, then the QP will be treated as an expert, just as an external auditor would be, for purposes of liability under the Securities Act. What that means is that the company would be required to get the consent in writing of the QP, and that consent would have to be filed with the registration statement. And if there were any material misstatements or omissions in any of the QP's disclosures, which would include the entire technical report summary, then the QP could be liable to purchasers in the offering for damages. So, in a large offering, if there was some major problem with the report that was discovered before the statute of limitations had run, that QP could be subject to a very major claim if the company went under and the QP was the only one left standing to seek a remedy against. One interesting thing here is that many Canadian companies, because they are required to comply with 43-101, are already doing this. So Canadian mining companies, when they file in the SEC, they're already naming QPs. They're already required to get consents from QPs. The QPs are already liable. Perhaps they don't all realize that, but this is really not a change for Canadian companies, but for U.S. companies it may well be.
Great. And so under the proposed rules, who is going to be a qualified person, and how is that defined and recognized?
Yeah. So first, I want to make sure people don't stop listening on this slide, because you can't just rely on the QP and say, the QP will figure out if they're a QP. Under the SEC rules, this specific statement is that the company is the one required to determine if this person is a QP. So companies can't defer to the QP. They've got to do their own due diligence to make sure the person really is a QP. To be a QP, there's two key requirements. First, the person has to have 5 years of relevant experience, which generally means 5 years of relevant experience in the type and style of mineralization on the property and the type of work that the QP is doing for the company. And the SEC's commentary on this is clear that it's a subjective analysis, and a person may well be a QP for certain types of properties and projects and reports and not for others. For example, a person who has only open pit experience is not going to be a QP for an underground mine. A person who has a lot of exploration experience may be a QP for an exploration report, but maybe not for a feasibility study. And of course, there are different minerals with different qualifications, and so someone could be a QP for coal but not gold, etc. But that's all a subjective analysis as to whether they have the requisite 5 years of relevant experience. The second piece is that the QP has to be a member in good standing of a recognized professional organization. And while some countries have adopted formal lists of approved organizations, the SEC has said it does not plan to publish a list. Instead, they plan to publish a list of the requirements that an organization must meet to be qualified. That includes, being recognized in the mining industry or authorized by specific laws. They must admit members primarily on the basis of academic qualifications and experience. They must require compliance with professional standards and ethics, require or encourage continuing professional development, have and actually exercise disciplinary powers, including powers to expel members, and publish a list of members in good standing. Interestingly, it is not proposed that a QP would need to be independent of the company, even for purposes of preparing the technical report. So that is a little more lenient than, for example, 43-101 in Canada. Under the SEC proposed rules, a company employee could potentially be the sole person who is relied on in all aspects as a QP. Also, you'll note that I didn't summarize any academic qualifications. There are none under the proposed SEC rules. As long as the person can get admitted to one of these acceptable organizations, there is no requirement for any, geology or any other type of degree.
So, if an issuer is responsible for making these determinations, I wonder if, in many ways, like an issuer has to determine if their auditor is independent, if they're going to be having those same kinds of conversations in either certifications or conversations with respect to a board or a committee regarding, independent qualifications, whether or not they are, not independent, my apologies, whether or not they are qualified. and whether or not all of the people weighing in on this are qualified.
Yeah, I think one of the interesting things that comes out of this is that our clients don't always get us involved in selecting a QP, the agreement with the QP. Often we don't even see those documents. But now that we would have a significant legal compliance component to all of this, I would strongly recommend that clients would get their external counsel involved in the process of retaining and instructing the QPs, because there would be important issues to think about, including what representations, warranties, and covenants should the company get from the QP in the retention agreement or otherwise? Should they require, for example, an annual certificate from the QP that summarizes that they meet all of these standards? And also involvement in monitoring and reviewing the work product of the QP at the draft stage before the document is done. Just like an SEC annual report has to comply with many different specific form requirements, a technical report summary will also need to meet very specific form requirements, and it would be important to ensure that in the drafting process there is a legal review of the report to make sure that it meets all those required standards. So Barney, as president of the Mining and Metallurgical Society of America and director of Behre Dolbear, I'm sure that you've been thinking a lot about these particular aspects of the proposed rules, and so I'd like to ask you some questions about these QP aspects. So first, what are your thoughts about the concept of requiring the use of a QP and the definition that the SEC has proposed? For example, would MMSA satisfy the definition of a recognized professional organization, and do you think the proposed definition might cause problems for any other organizations?
Well, first of all, I think the concept of the QP is a very valid one and an appropriate one. Regarding MMSA, has been in existence since 1914, and it was the first multidisciplinary organization in the country to adopt the qualified professional standard. The only difference between what MMSA requires and what 43101 and the proposed rules here are is that we require 10 years of experience, but we allow part of that experience to be some of the education that the individual has had. The real issue here to me is the fact that QP need not be independent. If my understanding of 43101 is correct, an independent QP is required on the initial document that's being produced. Subsequent to that, the in-house QP may do it. Here they're saying that no independence is essentially required, which I think can lead to some pressure being put on the qualified professional by someone within the organization whose goals are basically to keep the stock price up.
Yeah. And can I ask you as well, how do you see assuming these rules are adopted in their current form, how would the QP requirements affect the behavior of, independent firms who will be asked by companies to prepare technical report summaries? For example, have you given thoughts to how this may affect Behre Dolbear's practices in the market?
Well, I think it can have both a positive and a negative effect depending upon the specific client that you're working with. The effect on the client is probably going to be one where the QP that is going to do this will really want to have other QPs signing off on each aspect of the project that they're involved in. And this is suggested, of course, both under 43101 and under the proposed SEC rules, that would seek guidance from other experts who have more expertise, say in the metallurgical side and the mining side if it's a geologist doing the resource and reserve estimation, etc. But it also includes social experts, it includes environmental experts, geotechnical experts, hydrological experts. All of these things are going to require, or if someone's being prudent, would require a competent or qualified professional in each of these areas. And that could really mount up to increased costs for a firm's clients and increased revenue for a firm.
Thanks, Barney.
Thanks, Chris. Now we're going to take a brief overview of the actual technical report summaries and what those requirements look like. There are four principal types of reports that are contemplated by the proposed rules, which we see here. Those being the summary disclosing exploration results, an initial assessment, a preliminary feasibility study, and then a feasibility or final feasibility study. Significantly, we see that the SEC has added requirements on reports for exploration results, initial assessments, and pre-feasibility studies. Guide 7 previously only really recognized that you would have a feasibility study and didn't provide any real guidance on the requirements of the feasibility study other than it be final or bankable. And then they did provide some staff guidance on what that would entail. But now we've got three more technical reports that are specifically contemplated under the proposed rules. And these requirements of these reports, by and large, follow similar standards that have been adopted in the industry, including NI 43-101. These reports are required for material events affecting exploration, development, and production on your mineral properties. And the requirements for each of these types of reports, and in the case of economics to be presented in these reports, the modifying factors that you must consider in order to make those presentations are highly detailed rules. And while we don't have sufficient time to run through each of the aspects of those rules, you can find a discussion of those specifics in our corporate update on the proposed rules, which we previously provided and will circulate to the participants on this call. But a few items to highlight for consideration here. You will note that the initial assessment that's being contemplated is a bit narrower in scope than a traditional scoping study or even under NI 43-101, a preliminary economic assessment, and that the initial assessment sets forth requirements to establish a mineral resource, which in this case must include a qualitative evaluation of modifying factors to establish the economic potential of the project and include a cutoff grade that is based upon assumed unit costs and estimated prices. And if an economic analysis is performed, it must include detailed cost estimates and discounted cash flows. The requirements also establish specific levels of accuracy and contingency levels, as we've discussed earlier, relating to capital and operating costs. And you can see those at the bottom of the slide here. For an initial assessment, obviously these accuracy levels increase as you go to reports that have greater certainty. So initial assessment to pre-feas to feasibility study. So one question, I think the key question here for Barney is that these requirements raise many questions for many issuers as to whether or not it'll be even possible to comply with these new technical report summary standards and the standards for the preparation of technical reports under other reporting regimes, specifically NI 43-101. So I guess, Barney, do you think it will be possible to prepare one technical report that meets the requirements of both these standards?
It should be. I think that, 43-101 generally has a summary of the findings in it. What you're really looking at here is an expanded executive summary that does not go into the in-depth technical material, doesn't go into a detailed discussion of geology, just lays out the basic facts about the property or the project, and doesn't go into what age the rocks are, etc. but does disclose material facts about where it is, what is it, what type of deposit is it, what are the resources and reserves, what is the metallurgical process, what is the mining method, what are the environmental requirements, what is the title, etc., just going down the entire shopping list.
And what do you think are the biggest differences that might give concern to people who have traditionally prepared 43101 reports and might now have to meet the more strict SEC standards?
I think the most significant item is the difference in the commodity price that has to be used, because there is a difference in the requirements. It wouldn't surprise me to see most Canadian companies conform now to the 2-year trailing average. But I can't say that with any assurance. They certainly did seem to come aboard on the 3-year trailing average, or the lower of the 3-year trailing average, or the current spot price. The levels of accuracy that are presented, these are industry standards. I don't think this is anything new. As I said earlier, I think the biggest concern would be if in some way or other these would deem to be mandatory, because while it says plus or minus 50%, that's great for an initial assessment, but when you get to the feasibility level study, sometimes things go wrong that your contingency won't cover, and it's not untypical. Most mines during ramp-up incur problems that were never foreseen. That's the reason for the contingency, and that increases capital costs, can increase operating costs, and certainly uses up your contingency.
Thanks, Barney. Kim, maybe we can discuss some of the other differences that we're seeing between Guide 7 and NI 43101 and the new proposed rules.
Sure. So one of the differences, I'm sure all of you fondly remember when Sarbanes-Oxley came into effect, and the concept of having to disclose your internal controls for financial reporting. Welcome to the new rules. So one of the points is going to be disclosure of the internal controls used in exploration and mineral resource and reserve estimation efforts. So keep in mind, Guide 7 did not require this. However, this is very, very common for 43101, et cetera, for someone who is already subject to other kinds of reporting, whether it, one of the CERSCO standards. This is really not going to be new and is not going to really change things much, or at least that's the SEC's expectation. However, if you haven't done this before, if you're currently just subject to Guide 7, you would have to start describing internal controls that it uses in exploration, and mineral resource and reserve estimation efforts. It has to address quality control, quality assurance programs, verification of analytical procedures, and comprehensive risk inherent in the estimation. So, like we said, this is probably not going to be anything new or unusual for anyone who's currently subject to one of the other CERSCO standards, such as 43101. However, the SEC does acknowledge this would require, additional cost and effort if you are currently just subject to Industry Guide 7, because it is not required. And I'll just touch very, very briefly on the U.S. Geological Survey and Circular 381 and 391. This is used to classify resources of coal and other types of industrial minerals. In the past, the SEC has not objected to use of these circulars. Those are no longer they are inconsistent with the proposed rules. So we would expect, absent some changes in the comment process, that the ability to rely on those and use those would be set aside.
Thanks, Kim. Chris, maybe you can just kind of, to wrap things up here, can we go back through and talk about, what companies does this actually apply to, what companies would be excluded, and then what do you see as the transition and other cross-border issues for compliance, with the proposed rules if they were adopted?
Sure. So as we discussed earlier, the new rules would apply to all SEC filers except MJDS filers from Canada. And within that group, you must comply with the rules if you own, operate, or have royalty or similar interests in a mineral property. And all of those interests on the various properties that you have collectively are material to you. And there's a presumption of materiality at a 10% sort of standard in terms of value. So companies that have projects that are less materiality, even if they're U.S. companies or they're not MJDS filers, will not have to comply. I would like to talk a little bit about specific issues that would apply to different categories of companies under these rules if adopted in their current form. So first, issuers that have been following Guide 7 and actually declared reserves in compliance with Guide 7. For those kinds of companies, there's going to be two principal questions you need to answer. One, is the person who has historically prepared your reserve estimate a qualified person under the new test? If not, can they become a qualified person within the required time frame? And if not, you're going to have to go out and get a new person involved who is a qualified person to back up your disclosure going forward. Second, because the SEC is proposing to change the way that you calculate reserves, most importantly the change from a 3-year to a 2-year trailing average price as the cap, you'll need to figure out, do you need to restate your reserves the next time you do an annual report after the final rules take effect. The second category of company that has, I think, special issues is a foreign or U.S. company that is already subject to the disclosure requirements in another country, such as Canada. Those types of companies will have to consider the same issues that I just discussed, but they'll also need to make a broader evaluation of whether their existing technical reports filed in the foreign jurisdiction comply with the SEC standards. And if not, they'll have to think about what is the best way of, on a go-forward basis, complying with both countries' standards. One way of doing that, and the way that I think would be ideal going forward, would be that you would bring all of your disclosures up to the same standards if possible, so that you have the same disclosure being given out elsewhere. If a company were to decide not to do that, or if that's not possible, we would expect that companies would continue the existing practices of making the extra foreign disclosures available to U.S. holders through some other means, like a website, press releases, or an SEC submission that's not considered to be a filed document, like a Form 6K or a Reg FD Form 8K. Lastly, Canadian MJDS issuers. As I had said, Canadian MJDS issuers would be exempt from the new rules, but it is important to remember that these companies can and do lose MJDS eligibility from time to time. A company could lose its foreign issuer status. A company could have a reduction in their public float below the required US $75 million threshold. If that were to occur, the company would become subject to the SEC rules, and therefore MJDS issuers should consider how likely is that, and does it make sense for you to start to adopt some of the SEC practices so that if you do need to make a change, it's easier for you to do so.
So I think we should let Barney have the final word here. So I guess one final question for Barney before we sign off, and we'll give you 1 minute, Barney. If you could change one thing about these rules, what would it be?
I think I would focus more on the responsibility of the qualified professional. There's a real catch here, and that is that the professional who prepares these studies will probably have no impact on the way the feasibility study is finally affected in developing the project. That's beyond his control. and yet he might bear the liability for something that goes wrong there. I think that's a real major thing that needs to be considered and hopefully somehow corrected in the new rules.
Great. Well, thanks everyone for joining us. I guess one final question was asked is when can we expect to have to comply with the regulations? We do expect that the review period here, we've got a comment period until August, and then and that might even be extended depending on the number of comments that they're receiving. And then the SEC will take its time in considering those comments and actually proposing final rules to be adopted. And then as we've seen with the past adoption of new rules, it won't be likely that compliance will be immediate or even within a few months of the adoption of the new rules, but they'll have some sort of a transition period in which issuers will be required to comply with these rules. So I would not expect that even if we do get new rules by the beginning of next year, that issuers would be required to comply with the new rules probably until the fiscal years that begin probably a year from that date, or maybe even 2 years, depending on how the SEC wants to adopt and implement the transition period. So it's going to be a while before these new rules are actually going to be in effect and issuers are going to have to comply with them. And there will be a period of time with which to study the new rules and determine how you're going to comply with both foreign requirements and the new SEC standards. So I'd like to thank everyone for joining us on this webinar. It has been recorded and will be available for viewing after the fact. And we will send everyone a follow-up email who has participated on the call, both with that information and with the corporate update that we previously prepared that provides greater detail on the proposed rules and the preparation of these technical reports. So thank you everyone for joining us, and have a great day.